Ever thought about expanding your business to the US? Or maybe your company wants to send you, a key employee, to its American office. And today, we're pulling back the curtain to show you exactly how they structure a winning L-1 visa case. First off, what exactly is an L-1 visa? It's a non-immigrant visa designed for intra-company. This means it allows a U.S. company to transfer an employee from an affiliated foreign office to one of its offices in the United States. There are two main types. The L-1A is for executives and managers, and the L-1B is for employees with specialized knowledge. The goal is to bring valuable talent to the U.S. to help the business grow. Sounds straightforward, right? Well, the devil is in the details, and that's where the legal strategy begins. The lawyer needs to understand your entire business structure, both in the US and abroad. They'll ask questions like, how are the companies related? Is it a parent-subsidiary relationship, a branch, or an affiliate? What is the ownership structure? They need to establish what's called a qualifying relationship between the foreign and US entities. This is the absolute foundation of the case. Without it, everything else falls apart. Next, the focus shifts to the employee being transferred. The lawyer will analyze the employee's role, both past and future. For an L-1A visa or executive capacity for at least one continuous year in the past 3 years. This means they can't just have the title of manager. They must have actually performed the duties of one. For an L-1B visa, the challenge is proving specialized knowledge. Lawyers will collect evidence like patents the employee worked on, internal training manuals they helped create, or documents showing their involvement in proprietary projects. It's about proving this employee is truly indispensable. Once the lawyer has confirmed the qualifying relationship and the employee's eligibility, the next phase is building the petition itself. This is far more than just filling out forms. It's about telling a compelling story to the immigration officer. A crucial part of this is the support letter, which is often drafted by the lawyer on behalf of the company. This letter is the narrative of the case. It connects all the dots. It explains the company's business, the qualifying relationship, the employee's history, their proposed role in the U.S., and why their transfer is essential for the U.S. operation. A well-structured support letter will detail the U.S. company's operations and its business plan, especially if it's a new office. For a new office petition, immigration officers want to see that the company is serious. The lawyer will include evidence like a commercial lease for office space, a corporate bank account with sufficient funds, and a detailed business plan with financial projections for the next few years. This shows that the company has made a real investment and isn't just a paper company. The business plan will outline the goals for the U.S. entity and explain how the transferred employee is critical to achieving those goals. For example, it might state that the manager is being sent to hire the initial team and establish the U.S. market presence. The amount of documentation can be staggering. We're talking about corporate registration documents, tax records, financial statements, payroll records, articles of incorporation, and shareholder lists for both the U.S. and foreign entities. For the employee, it's employment verification letters, resumes, pay stubs, and educational degrees. The lawyer's job is to organize this mountain of paper into a clear, logical, and persuasive package. Each piece of evidence is carefully selected and tabbed to correspond with the claims made in the support letter. This makes it easy for the immigration officer to review and verify the information, which can significantly speed up the process and increase the chances of approval. One area where lawyers add immense value is anticipating and addressing potential red flags. For example, if the company is small or the ownership structure is complex, the lawyer will preemptively provide extra evidence to clarify the situation. If the employee's managerial duties aren't immediately obvious from their title, the lawyer will provide a highly detailed breakdown of their daily tasks. This proactive approach is key. If USCIS issues a request for evidence, or RFE, it can delay the case by months. A well-prepared petition aims to answer all the officer's potential questions before they even have a chance to ask them. Let's talk more about that request for evidence. An RFE means the officer isn't convinced and needs more information. This is where having a lawyer is truly critical. They can decipher the often vague language of the RFE to understand exactly what the officer is questioning. Is it the specialized knowledge, the managerial duties, the qualifying relationship,